Public hanging, burning alive, lethal injection, taunting, torture, throwing stones, the gas chamber are all types of the death penalty. And despite our long and brutal history of putting people to death, there are still arguments going on today. So, we will be discussing the constitutionality of the death penalty. The United States was founded on July 4th, 1776, and our Constitution was signed in on September 17th, 1787. The Constitution is what is used in modern times to decide the appropriateness of the death penalty. In our Constitution, the Eighth Amendment prohibits cruel and unusual punishment, but the determination of which punishments are cruel and unusual and thus unconstitutional have been left to the courts. According to the Supreme Court, punishments are cruel when they involve torture or lingering death. But not all punishments are cruel. And this definition implies that there is something more cruel than simply executing someone. And in 1972, the Supreme Court ruled in Furman v. Georgia that the death penalty, as it was being administered under then existing statutes, was unconstitutional. These opinions are largely focused on the procedures by which convicted defendants were selected for the death penalty. The impact of this famous trial was dramatic and emptied many death rows across the country. Some argued that the decision of Furman was a deep-seated concern about the fairness of the death penalty process. As a result of Furman, many states responded by adopting new statutes designed to narrow the discretion and thus avoid the problems of arbitrariness and discrimination identified by the justice in the majority. The new statutes gave two avenues that could lead to the death penalty. Some required the judge or jury to impose the death penalty of a defendant who was convicted of first-degree murder. Others permitted the judge or jury to impose the death penalty on defendants convicted of certain crimes depending on the presence or absence of aggravating and mitigating circumstances. These guided discretion statutes also required a bifurcated trial in which the jury first decided guilt or innocence and thus decided whether to impose the death penalty. They also provided for automatic appellate review of all death sentences. The Supreme Court ruled on the unconstitutionality of the new death penalty statutes in 1976. The courts held that the mandatory death penalty statutes enacted by North Carolina and Louisiana were unconstitutional because many of the problems prior to Furman v. Georgia. In contrast, the Supreme Court ruled the guided discretion death penalty statutes adopted by Florida, Georgia, and Texas did not violate the Eighth Amendment. Since 1976, the Supreme Court has handed down additional decisions on the constitutionality of the death penalty. The decisions ruled that the death penalty cannot be used on defendants convicted of raping an adult or a child. It did say, though, that those that displayed reckless indifference to the value of human life during felony murder could be executed. This evolution of the death penalty has come a long way, and there are those that still have problems with it, and it is a evolving thing.